The corruption trial of Nigeria Senate President Bukola Saraki at the Code of Conduct Tribunal has been adjourned till June 15th. Saraki has pleaded not guilty to 16-count charge of false declaration of assets while he was governor of Kwara State. The tribunal says the case was adjourned to allow the defense counsel, Kanu Agabi, time to see his physician for routine medical examination. Saraki returned to the courtroom Tuesday morning after weeks of adjournment. The lead prosecutor, Rotimi Jacobs, has accused the Senate President and his legal team of intentionally delaying the trial. He strongly objected the adjournment, demanding that the court must finish the cross-examination of prosecution witness Michael Wetkas, which began about 2 months ago.
Actually, today we made some considerable progress because we're actually lumping 3 of the counts together, counts 7, 8, and 9. And that is because they relate to the same property. Now that is one. The second thing that we've really achieved today is it's been established again that that property belongs to Carlyle, a company, and it is not the property of the defendants. Now that is critical because as we have already established on previous sittings, the personality of a company is totally different from that of an individual. It's a corporate personality and it's on its own. And if it owns a property, that property does not belong to its shareholders. So even if the defendant is a shareholder in any company, the property that that company owns does not belong to the defendant.
I'm concerned that a letter can be written to the tribunal that they were not going to sit, they were not going to appear tomorrow, Wednesday and Thursday. That was originally scheduled to the case was scheduled, and there was no copy with that letter. I got to know about this only when the tribunal was about to adjourn. I think that is not fair to us. They were not fair to us in not letting us to at least to know that this is what they are going to do. And I keep on saying that all these are deliberate attempts to frustrate this case and buy a lot of time. So I heard him talking to you that the company is a different company and that we are losing ground. Why are we losing ground? We disclosed this from day one. When you knew that we are investigating you, you declared this property only in 2015 as belonging to you. You disclosed some of them in 2007 as belonging to you. This company, you mentioned that the company, you are having controlling shares of those companies, and yet you are denying now that you don't have those company, the company does not belong to you. So all this shows that the antics that is trying to play out, and at the end of the day, everybody will see that there is no basis for all this. There is no basis for this cross-examination. There is no basis for all the questions they have been asking, because these questions are not relevant. Did they declare this asset? Did they not declare this? What did they declare? These are the issues. It's not the ownership of a company. What you have to declare is not only your own property. You have to declare the property you have in the name of other nominees. So that is what they don't know. The declaration of asset does not, even the asset of your wife, you must disclose it. So, and your children, you have to disclose those assets. So you can't incorporate a company and put property in those companies and say, no, I will only declare it's convenient for me. He declares some in the name of those companies and refuse to declare the other. And you are now saying that the companies are different. So it's a total deceit.